Hello all, welcome back to some of you, and hello for the first time to quite a number of you. Look, my name is Chris Hines. I'm Strata Advisor with Hines Legal. With me today is Frank Higginson, partner at Hines Legal. Frank.
Hello, everyone. Good to see everyone on a Friday afternoon.
Absolutely. So, look, first of all, sincere apologies for before. Technology is wonderful, isn't it? Anyway, so we figured it out. We're here. What more could you ask for? Frank,
Alcohol.
I don't think we could ask for anything else, could we?
No, just alcohol.
Putting that to one side for now, welcome everyone. In all seriousness, thank you for giving up a bit of your time on a Friday afternoon to listen to us yak on for a while. We're going to talk today about legislative change, and it's interesting, Frank, isn't it? Sector in Queensland has been banging on about legislative change for years, literally. And then this week they got it in a matter of days, and it wasn't the legislative change they expected.
No. And some of it, to be fair, not a whole lot of it was actually telegraphed. Some of it probably could have gone a little bit further. So it'll be interesting for everyone out there to hear a slight difference of opinion between Chris and myself. And obviously, we've had a little run through in terms of what we think this should look like. And we're not quite in agreement on one or two things, or one thing in particular. So, and I suppose part of that is Chris has obviously got a substantial government background. I've got a legal background, and I'd suspect that one particular provision of this may be tested in the Commissioner's office at some stage. So the adjudicators will have something to say about what government actually meant.
Without question, Frank. Just a quick note to everybody, you can ask questions live. There is the chat function on Be Live for you to enable you to do that. Frank and I already have a bunch of questions which have been posed to us over the past 24 hours. So we're going to try and get through those as well. If we can't get through all your questions today, we'll endeavour to get to those as soon as possible after the event. And just a reminder, this is being recorded, so it is something that you can refer back to. And it goes without saying, but having said that, I'm going to say it anyway, we're not providing legal advice here today. We're providing you with our views, general information. If you do need advice on a very particular situation to your circumstances, you will need to seek advice, perhaps from a body corporate law firm, Frank.
Yes, so we can find a good one to refer them to, Chris.
With that in mind, look, let's get straight into it. So let's just clarify what has occurred. So this week, Parliament in Queensland sat and passed an emergency bill. Unlike other situations in Parliament where a bill is introduced and it takes a matter of months, if not years in some cases, for that legislation to pass, this passed in a couple of days, literally. Important to note a couple of things. This is not the regulation that has been talked about for some time, nor is it the regulation that was referred to with the first COVID emergency bill a few weeks ago. This is an entirely separate amending bill which amends the Body Corporate and Community Management Act. So that's the first point. The second point is we don't know when these things start. So while the legislation has passed, it has not commenced. We would expect that commencement would be a matter of weeks, and not many weeks at that. You'll have to stay tuned for that. We await further advice from government about that. And I see we've got a question coming through, so I'm pleased because that means people can actually see and hear us. This is fantastic news for everybody. The bill amends a whole bunch of acts in Queensland. Today we're talking about body corporate and community management, and we might, if we get time, briefly touch upon BUGTA as well. The changes are in 5 distinct areas. Frank, let's rip right into it, shall we? I should, before I forget, you can access a copy of the legislation, www.legislation.qld.gov.au. You will choose the Bills tab, and you're looking for the Justice and Other Legislation (brackets COVID-19 Emergency Response) (brackets Amendment Bill 2020). Frank, the first thing that's been amended is sinking fund budgets.
It is. So I suppose we've been dealing with lots of questions from bodies corporates about the ability to amend budgets. So it's probably first thing, there's no ability to amend an administrative fund budget. So an admin fund budget in theory should zero out every year. A body corporate needs to spend 100,000 on insurance, 70,000 on caretaking fees, 20 grand on their strata manager, whatever it might be. Those amounts are still there. They need to be raised. There's no ability to cut them. End of story. But sinking funds, the government has created, and dare I say it, Chris, it's sort of the law of unintended consequences is what we'll be dealing with here, I'd suspect, in probably 2021 somewhere. So what the government has created is the ability for bodies corporates by ordinary resolution at general meeting, so this is not a committee decision, it needs to go to owners for approval, to effectively carve items out of their sinking fund budget. So a sinking fund budget, not in theory, in practice, should have 10 years worth of anticipated capital expenditure on the building. So insurance is a year by year, it's an annual thing, it's recurrent expenditure. Capital expenditure is things like lift replacements, roof replacements, refurbishing pools, repainting the external walls of the building, whatever it might be. And the theory behind a sinking fund budget is that there's no massive surprises with special levies on owners to say, hey, we're short 300 grand for the lift replacement, you all need to pony that up now. What the government has created is the ability for bodies corporates to do, effectively, to me, two things. The first is to remove items from their sinking fund budget that they're otherwise required to have in there. So say, for example, and the easiest one might be, it's going to cost $1 million to repaint our building.
Yep.
And what we do is we raise $100,000 a year over a decade.
Yep.
So if that was forecast for 2025 to be needed to be repainted, thus far through 2020, we've already raised $500,000 and we've got $500,000 to go. So what the government has created here is the ability for the body corporate to go, you know what, we're going to take that $500,000 that we still need to raise out of the budget, which effectively, I suppose, for the rest of this year would reduce that sinking fund by near enough to 50 grand. That's half of the year's amount that needs to be raised. And the second part is if the body corporate actually does that, it must refund the 500,000 that it has already raised back to owners.
And that's a really important point, Frank, that must. So in legislation, the two big terms to always look out for are may or must. May suggests that there is an option available to the entity, but must, when it comes to legislation, means there are no options. It has to be done. It is an obligation. So in this case,
express. Body corporates must do it, and body corporates, in a sense, are not like companies where they pay dividends. There's no real ability to refund monies to members, so that's going to be a bit of a logistical nightmare for strata managers. And the other thing to me that jumps out is that there's some bodies corporates around that have, very forensic sinking fund forecast, almost to the dollar to the month in terms of what needs to be raised, but that's not. It's a statutory requirement to have a sinking fund forecast. It's not a statutory requirement to have it right or to have it done professionally, because in theory they can be done on the back of beer coasters. So if we've got some very rubbery sinking fund forecasts out there, that same example before with the $1 million raised over 10 years might not be quite as precise for those that have not got the data behind it. So that'll be an interesting exercise in terms of what people decide to do there.
And Frank, a couple of interesting kind of points leap out at that. When we the legislation talks about refund, it does not talk about applying that money as a credit against levies. It mentions the word refund, and I think you and I are in agreement on this, that refund means giving back money, cutting a check, basically.
It does. And even our $500,000 example, even if that has been raised effectively from not all of those lots you would think would be in the same ownership for that previous 5-year period. So if you purchased one of those lots yesterday, then you may be getting a check for your proportionate share of that $500,000 over the 5 years of raising that's been paid for by the previous owner.
Yep.
So that is actually a check in your pocket.
But let's remember, it must be agreed to ordinary resolution at a general meeting that this is the course of action.
And then for me, and this is the unintended consequences bit. So we're spending a little bit of time on this one because I think this is something that people will be jumping at, and it's in, some of the other ones are easy. There's consequences for this is that come 1 January 2021, in the absence of anything changing from a legislative perspective, bodies corporates go back to exactly what the legislative position is at the moment, in the context of they must have a 10-year sinking fund forecast, which covers the capital expenditure that's going to be required. So back to our painting example, we have our building that needs to be painted in 2025 and it's going to cost $1 million. So the first thing effectively that body corporate needs to do with its next AGM budget is raise the 550,000 that it's effectively forgiven, or maybe the 600 at that stage, because we've got 5.5 years to date, 6 months worth of rip out. It's got to go and raise that again from owners. So effectively, to me, it would kick the can down the road for 6 months, and then there would be an enormous amount of pain.
And the issue that's going to potentially create is for those owners who are looking at selling their lot. So probably should have clarified right at the start, and my apologies for being remiss on this. This legislation expires on the 31st of December 2020. So this is time limited temporary legislation. That's why Frank mentioned the 1st of January 2021. So what you've got is a situation where body corporate's gone through this process, has made this decision, refunds, great, everyone's happy, refunds, woohoo. The problem here will be that, as Frank just said, to put it in the vernacular, at some point you have to pay the piper. At some point, the levies go back to where they need to be. So this, remember, temporary situation now, 2021, no longer a temporary situation. We go back to where we have always been when it comes to sinking fund. Those levies, if you've taken that course of action, are going back up. If you're selling your lot, that poses a big issue for a prospective purchaser who will see the amount of levies payable skyrocket, won't it, Frank?
Absolutely. And I think the other thing is that it actually, and it's really interesting legally, and so here, I'm not a very academic lawyer at times, but when you look at this bill, it's extraordinary the amount of legislation that's been amended. So Chris, in his prior life, has actually drafted legislation. And I asked him, how do they, because from a legislation drafter's perspective, all we do all day is deal with the BCCM Act, so we're relatively familiar with its provisions. When you're in, was it the Office of Parliamentary Counsel, Chris, and you're dealing with the legislation for all of the state, you obviously got to be across everything. And it's sort of the question is, how do they actually understand where they need to go and what they need to do? So it's an enormous exercise. So one of the other things that then comes up is, so these laws have been made in relation to financial commitments. One of the other things that happens from a Body Corporate and Community Management Act perspective is that there's an obligation to disclose. So normally in property in Queensland, we have the phrase they teach you way back in contract law, caveat emptor, buyer beware. So that really comes down to the regime of, it's not usually for a seller to be obliged to disclose to a buyer problems with a property. So for example, if you're selling your property and there's termites in it, the buyer has a right to go and get a building and pest inspection, but there's not an obligation on you as a seller to say to a buyer, oh, there's termites downstairs. That's what caveat emptor means. From a body corporate perspective, that gets turned around. So when you go look at section 223, for those of you that are keen, there's a bunch of implied warranties. So the BCCM Act creates a number of implied warranties in every contract for the sale of a strata title lot in Queensland. And those warranties include, particularly subsections 223, 3 and 4. The seller warrants at the date of completion of the contract, to the seller's knowledge, there are no circumstances other than circumstances disclosed in the contract, so things that are actually stated in relation to the affairs of the body corporate likely to materially prejudice the buyer. Obviously, materially prejudice is the legal word that where legal wars are fought and won. But my immediate take would be that if the body corporate has taken $600,000 out of its sinking fund and given it back to owners, and that is likely to have to be levied again on the 1st of January 2021, or reframe that, when that next body corporate sinking fund budget comes around, to me, that is something that could materially prejudice a buyer. So I think it would require disclosure to the buyer in the contract, and it'd be dangerous not to do that.
Look, I think so too, Frank. I mean, at the end of the day, the disclosure regime is based upon full transparency to the prospective purchaser, be fully aware of what they're getting into. So disclose, absolutely. continuing on that theme, Frank, I might duck over to some questions just to sort of break things up a bit, but they go towards what we've just been talking about. So one of the first questions we got, what happens if the committee says it has not got enough money in its levies to pay the caretaker for the month? Couple of answers to that one. That's a contractual issue and you'll need to seek legal advice for that. But there's another answer to it, Frank, isn't there?
Absolutely. Is that there should always be the money in the administrative fund, which is where the caretaking fees are paid from. So to me, if there's not enough money in there in relation to the administrative fund, there's no right to waive payment of levies. The body corporate effectively, in a vacuum, has an obligation to go strike a special levy on its owners to fulfill that gap. So a body corporate cannot be insolvent. They cannot sink. They must go and raise money from their owners if there's a shortfall. So there should not be that position.
And then another question, which is kind of related to that. If the body corporate has collected substantially more levies than required for the payment of annual insurance levy, can the committee elect to carry over the surplus, or will it be required to refund the surplus collected in the current financial year? A bit confused by this one, Frank. I'm not sure how excess insurance levies can be collected.
Because my experience, and I think your experience as Commissioner certainly, is that insurance is going up, not down. So it's pretty rare to budget 100 and the premium only come in at 70. But to me, if it's in the administrative fund, there's no ability to refund it. That only relates to sinking funds that have been removed by ordinary resolution or sinking fund line items. And then after that, the way to deal with that, to the extent there is a surplus in the admin fund, would be to reduce the admin fund levies by the amount of that surplus for the next year. So if we've raised 100, we've only spent 70. Effectively, there's a 30 grand bonus sitting in there. So that should just be as a credit effectively for that next 12 months. The
budget gets adjusted in the next financial year. And that's probably a good moment to clarify. There's no broad capacity to refund levies under the legislation. The only capacity is this time-limited legislation that we've just finished talking about in relation to the sinking fund. There is no broad capacity otherwise to refund levies. Another big no-no is the interchanging of money between admin and sinking funds.
Cannot do it.
No dice.
Yep.
No dice.
Nope.
Might quickly jump down, Frank, to another of the 5 amendments, and this also relates to a question, but I think can be very quickly covered. Somebody asked us in advance, can the body corporate as a legal entity borrow money from the bank? And the answer is yes, they certainly can, and this bill covers that, doesn't it?
It does. It does. It does. And it's quite interesting. Bodies corporates don't, I suppose where we get a lot of our content from is what's coming across our desk from a day-by-day basis. Obviously, the bill arrived Tuesday, newsletter Wednesday. Here we are talking about it Friday. Happy days. We're helping a few bodies corporates with loan documents, special resolutions, quotes and all that sort of thing at the moment. And they are borrowing. Which I have not really seen a lot in the last decade. But the shortest of short versions is that the way it works at the moment, well, standard provisions of the legislation basically had a cap of $250 per lot by a body corporate could borrow by ordinary resolution. Anything more than that, if it was in the standard module, it required a resolution without dissent. If it was in the commercial or accommodation, it required a special resolution. That is different from raising special levies, so it's always been a little bit prohibitive, I suppose, in that sense, the higher threshold bar, and maybe that's a disincentive for bodies corporates to borrow. What they have done in this amending regulation is effectively doubled those caps during this COVID period. So through 31 December this year, if bodies corporates want to borrow, they can do that by borrowing up to $500 per lot by ordinary resolution, and then those previous caps kick in. So it is allowing it, and I'd suspect we'll see a bit more of it. And if that's only for the fact that I've just seen more of it across my desk in the last couple of weeks than I've seen in years.
It's clearly out there as a viable option at the moment, borrowing. But I would say, regardless if it's a body corporate or an individual borrowing, you need to take all your necessary steps before you enter into an arrangement to borrow money. There are a lot of obligations that go with it. With that in mind, we might hop to the next one, Frank. This is about contributions levied by the body corporate. So the amendment that will come into force only applies if the body corporate has fixed the contributions and fixed the dates for contributions or for the contributions to be paid in instalments. So this will only apply if those contributions have been fixed by the time this legislation starts. And the legislation goes on to say the committee may, I stress it's may, it's not must, decide to extend the due date for payment of a contribution to a day that is no later than the end of the financial year. More than that, Frank, the committee may decide to do that for an owner if they're satisfied that the owner is suffering COVID hardship, or they might decide to do it for all lots, regardless of whether owners are suffering because of COVID. What do we think about that?
Another interesting one in terms of can down the road. And I suppose this might lead a little bit back to that first question we were talking about, the caretaking salary, because one of the caveats that is built into this particular provision is that if a committee does decide to extend the due date for payment of levies to the end of the financial year, it must consider, this is the committee, must consider the body corporate's ability to meet effectively its financial commitments. So to me, that says it's all well and good. So and again, back to body corporate financial years, they're not 30 June like all of us for tax. They can be any one of the 12 months of the year. Comes back to the budget period and the rest of it. So if your financial year ends on the 31st of December, say today, once this act commences, the committee can say to everyone, okay, you know what? You don't have to pay your levies till the end of the year. Merry Christmas. But that's only the case if the body corporate can still continue to meet its financial commitments. Yep. Now, there is going to be evident, obviously, some disputes around that, and I think this will depend a little bit on where buildings are actually situated. Chris and I are talking to Strata managers and Strata people in Strata communities every day, all day, basically, and that's from management rights owners, Strata managers, lot owners, et cetera, and definitely those that are in schemes where permanent long stay accommodation, I think are travelling a whole lot better financially, obviously, than short stay. And you go Gold Coast, Sunny Coast, there's a mix. I think the further north you go, the harder it sometimes gets. So this will be an interesting thing to apply, I think, particularly for those. So, for example, you go into Port Douglas, where there is a lot of short stay accommodation, a lot of people that won't be getting the revenue they might have otherwise got, and committees running a very, very fine balancing act in terms of the ability to give some form of relief versus still having to meet its financial commitments. So the rights are there. The question is still, committees having an obligation to act reasonably, and the committee can make this decision. This isn't a general meeting one. They've expressly stated in the legislation that committees can make this decision. So if you are a committee member and you are thinking about this, it's really important from a cash flow perspective to figure out what the ongoing financial commitments of the body corporate are, to make sure if you do give extensions, that you're actually still able to meet those.
Yeah, absolutely. So it does not avoid the body corporate's responsibility to meet its outgoings. It just provides another option to manage that, which relates to one of the questions that we had. Would an owner be unfinancial if their levies are not paid on time during the COVID period? Interesting question. I think, Frank, we're in agreement on this, that if the body corporate's made a decision to extend the due date, then maybe not. Maybe they won't be unfinancial.
I think if you haven't gone overdue on your levies, then you can't be unfinancial.
That's right.
So yeah, I think if everyone, again, back to that example, 31 December, everyone stop. Everyone remains financial for the entire year. But other than that, if those dates aren't extended, then we're talking about, I suppose, where we might disagree next. If you haven't paid the principal amount of your levies owing, you will be unfinancial, which will then disentitle you to vote, disentitle you to nominate for committee and so on.
Yep, absolutely. Leads nicely into the issue of debt recovery. So just to clarify, at the moment, the legislation puts an obligation on the body corporate to commence proceedings for debt recovery 2 years and 2 months after the debt becomes evident. The new legislation says that the body corporate does not have to do that. So that 2 years and 2 months obligation is not on the body corporate now in this COVID period. Having said that, that does not mean the body corporate cannot recover. It just means that they are not obliged in the same way. And importantly, I think, Frank, if there were proceedings started before this legislation commenced, that's unaffected, unchanged.
Absolutely. And I think probably one of the little savings provisions, I suppose, at the back end of these amendments is that if, say, again, practical example, 2 years, 2 months falls due next month for a body corporate, and they choose, we're actually not going to pursue that owner for whatever reason, etc., etc. Come 1 January 2021, the body corporate has 2 months then to get back on the front foot and do what the Act would otherwise have required it to do now. So if you do give people breaks, and that's completely obviously now a statutory right to do that from a committee perspective, you're not going to have the ability to do that come next year.
Yep. Yeah, so it's really important to remember that. The final amendment that's being put forward here is about penalties. So the owner of a lot does not incur a penalty for late payment during the period, or because another contribution is otherwise in arrears during the relevant period. Interesting one, isn't it, Frank? Because one of the things it does not cover is the issue of discounts.
No, and this is where Chris and I are, you wouldn't call it furious disagreement, but we've got a divergence of opinion. So the Act refers to and defines penalty and refers to and defines discount. So from a legislative perspective in the BCCMA, they are two separate things. Penalty is the 2.5% interest per month that a body corporate can charge on overdue levies, which is 30% per annum. And in one of our conversations with Strata managers this week, one of them did raise that might be a little bit excessive, and you look at it probably in a vacuum, and yes, it is, but clearly there was a parliamentary intent to encourage people to pay levies. And then the other thing is the discount. So if people pay levies on time, a body corporate can give a discount in relation to those. So that's where Chris and I have probably got there's two schools of thought, really. One is you can take the strict reference to what penalty is in the existing legislation, which refers only to me to be interest. The other thing is that you are in effect suffering a penalty if you can't pay your levies on time because of COVID, which removes your ability to get the discount. So they're the arguments, I think, that someone will run via the Commissioner's Office at some stage to whether losing the discount is a penalty if you can't pay your levies. So it'll be really interesting to see. That did come up in terms of the debate in Parliament, and the government actually, I think, didn't amend the legislation to specifically refer to it, but there is definitely two ways to look at it. Yep. So
look, I mean, my view is that the whole intent of this legislation is financial relief. And so therefore, if there is an option to provide financial relief, it would be more in keeping with the spirit of the legislation to do that than to not. That's my view. As Frank said, there are different ways to think of that.
And I suppose if you come back to where, the primary authority of adjudicators to make decisions, they're allowed to make orders that are just and equitable in the circumstances.
Yeah.
So if you look at it in that light, in terms of what the government's trying to achieve with this legislation in terms of relieving the financial burden and not further punishing people that can't pay their levies, then allowing a discount, regardless of whether people can pay it or not, would be very much similar to not hitting them with penalty interest.
I think so. I guess that's the extent of the amendment. I just
and probably, mate, the only other thing would be BUGTA. So what we've got is BUGTA. Absolutely, probably 1,000 buildings in Queensland with that Building Use and Group Titles Act. So particularly mixed use, big schemes built under the Integrated Resort Development Act and Mixed Use Development Act and South Bank Corporation Act and those sort of things. There's not as many equivalent provisions in BUGTA as there are under the BCCM. And in a sense, you'd say the BCCM Act sort of tidied up a lot of the things that were left out of BUGTA. So the one similar provision for BUGTA that in relation to these amendments is the ability for committees to extend the date for payment of levies to the end of the body corporate's financial year. So all BUGTA schemes have that same right. So, and of course, comes with those same risks and the same obligations to make sure that the body corporate can still meet its financial commitments.
Yep. So in the very short time we've got left, I think the message out of all of this is that these are pretty sensible amendments. Government could potentially have gone a bit further. Frank, on a few things, but
They could have.
the decision's been made here. I think the clear message from government is this, that each body corporate is still responsible for its financial affairs, and you still need to sort it out for yourselves based upon what is right for yourselves. Here are some further tools of flexibility to enable you to do that.
And Chris, can I just bump in?
Yeah.
Obviously, we have lots of people watching, and I'll give a shout out to one very experienced Strata manager who has texted me a question rather than put it up publicly, which is a bloody good one. In the case of a refund back to owners of sinking fund levies, what are the tax implications? And that is an excellent question. So what I would say to all people, if you are going to get a check back from your body corporate, you'll need to make sure you talk to your accountant about what that actually means, because I'd suspect that people may well have, if it's an investment property, claimed that as a tax deduction for years gone by. So whether you have to then put that on income or capital account or something like that will be a very interesting question. So there's another layer of complication in terms of refunds.
Yep. Okay. I think that the message here is that this is short-term, limited. Here are some options, but you need to think very carefully about if these options are actually going to work for you long-term. Don't take just a short-term view. All this is to get you over the hump. You've got to have your eye, if you're part of a body corporate, and particularly if you're part of a committee, you've got to have your eyes on the longer-term picture. The other thing which really rams home to me, Frank, is the need to get expert advice regardless of the issue. If you're a body corporate, and particularly you're in a committee, and you're looking at all of this stuff and a lot of questions are coming up for you, don't assume things. Don't just make a decision because you think it's right. You need to be sure. So whether that's legal advice, financial advice, technical advice, look, I know it costs money, but it probably will save you a whole lot more money in the long run. And how about we finish, Frank, with one of my favourite topics, and I know one of your favourite topics, a question that's come through on the chat function, not strictly related to...
Oh, don't do pools.
Yeah. Not related to financial stuff, but a question. I would like to ask a question regarding reopening of pools. Although the government has allowed pools to reopen, which is correct, does the committee have the right to keep the pool closed for now? My response to that is, well, what reasons are they giving for that? If the Chief Health Officer has seen fit to issue a directive that pools reopen with conditions, and there are some pretty strict conditions on pools reopening, if the Chief Health Officer has seen fit to do that, why would a committee think that they know better, frankly? Not only that, there has been an adjudicator's order issued from my former office a couple of weeks ago, in which an adjudicator made very clear that they were very doubtful that a committee has the power to regulate access to common property. Frank?
Completely agree. So the other thing I'd probably say in terms of sinking funds and those sorts of things, obviously if you read, subject to where you get your information from, there could be pressure on property prices. And my take would be is that valuers and banks would take a relatively dim view in relation to the future capital value of properties where people had raped and pillaged the sinking fund. So if we've gone and cut it back to zero, given everyone 3-4 grand back, knowing that on the 1st of January, we're not going to have to deal with it again, that is not going to go well in valuation land. So I suppose if you take a really, really short-term view, I'm going to sell, get out, not disclose at 21, which I think would be completely legally incorrect. That might work, but if you're taking a longer-term view and still going to be there in 8 months' time, I think it's just a matter of, for me, I suppose, being a little bit more, what would you call it, reticent about financial aggressiveness, managing cash flow as well as possible, and staying on top of it.
Absolutely. With that, that brings us, I think, to the end. Thank you, everybody, for tuning in, and thank you again for everybody for your patience today. Frank, you...
2 o'clock next Friday, we will be doing another one of these. Topic to be confirmed. We'll announce it earlier in the week. So probably we're going to keep these very relevant, very topical, very on top of the issues of the day. So hopefully next week we'll certainly be able to confirm where we've got to in terms of commencement dates.
I think we definitely try and follow this one up, Frank, to the extent that we can next week. But yeah, stay tuned for the topic. It's good to create a sense of anticipation, I think.
Yes,
but
absolutely.
Yeah, thank you everybody for tuning in. Thank you for everyone's patience who tuned in a bit earlier as well. Really appreciate you sticking around for this one. Let's do it all again next week, Frank.
Have a good weekend, everyone.
Yep. See you.
Okay, bye.
Bye-bye.